Your supervising attorney has been taken to the hospital. You think you can win this?
Yes.
She was the intern. Her name was Adiz Mensa. She was in the second month of her third year of law school. She had never argued a motion in an actual courtroom. She had mooted twice in a clinic setting and once at a regional competition where she had placed second. She was looking at Judge Harlow. Judge Harlow was 64 years old. He had been on the Fulton County Superior Court bench for 19 years. He had seen everything a bench saw in 19 years and had developed, through that seeing, the specific, compressed skepticism of a man who had watched a great many people stand in front of him and attempt to do things they were not adequately prepared to do. He looked at her. He said, "Counselor Mensa." He used the title not as recognition but as irony. She was not a counselor. She was an intern, and the title in his voice carried the full weight of its inaccuracy. Your supervising attorney has been taken to the hospital. The defendant's motion to dismiss has been pending for 6 weeks. We have a courtroom and we have a docket and we have 47 minutes before I need to move to the next matter. He paused. You think you can win this? The room was very quiet. 11 other people in the courtroom. 3 rows of benches. The defendant's counsel, a man named Harold Voss, senior partner, 31 years of practice, sitting at the opposite table with the specific, barely contained expression of someone who has already decided what is about to happen and is simply waiting for it. Adiz looked at Judge Harlow. She said, "Yes." He looked at her for a moment. He said, "Then sit down. We begin in 3 minutes." And in 44 minutes, in a Fulton County Superior Court on a Wednesday morning in March, something would happen that Harold Voss had not anticipated and that Raymond Harlow had not expected, and that the clerk sitting at the side of the room would describe, later, to a colleague who asked about her week, as the most surprising 44 minutes she had spent in a courtroom in 11 years of clerking. Stay with this story. Subscribe, because what Adiz Mensa did in those 44 minutes is not something that law school produces on its own. And understanding where it came from requires knowing who she was before she walked into that room. But to understand that, you have to go back. Not to law school, not to the moot competition. You have to go back to a kitchen table in Accra, Ghana, where a woman named Abina Mensa taught her daughter that an argument was not something you made. It was something you built. The Fulton County Superior Court on a Wednesday morning had the specific, institutional atmosphere of a system that did not wait for anyone. Not for emergencies, not for absences, not for the sudden cardiac event of a supervising attorney who had been arguing this motion for 6 weeks and who was now in an ambulance on I-75. The motion in question was a motion to dismiss a wrongful termination lawsuit filed on behalf of a man named Cedric Wallace, 47 years old, who had worked for 22 years as a structural engineer at a construction firm called Hargrove Building Solutions, and who had been terminated 8 months ago, 12 days after he filed an internal complaint alleging that the firm's project manager had systematically falsified safety inspections on 3 projects in the previous 2 years. The firm's motion to dismiss argued that the termination was unrelated to the whistleblower complaint, that it was the result of a documented performance review process that had begun 6 months before the complaint and that had identified specific deficiencies in Wallace's work product. The plaintiff's opposition argued that the performance review process had been manipulated retroactively, that documents had been backdated, that supervisor statements had been altered, and that the timing of the termination, 12 days after the complaint, created an inference of retaliation that was sufficient to survive a motion to dismiss. Adiz had been working on this case for 6 weeks, not as the lead, as the intern who did the research, who pulled the case law, who had read every document in the file and had built, over 6 weeks, the complete factual and legal architecture of the opposition. She had not expected to be the one arguing it. She had been standing in the hallway when her supervising attorney, a man named James Ose, who had been at the firm for 12 years and who was the most meticulous litigator she had ever observed, had put his hand on the wall and said, "I need to sit down." And then he had not sat down. He had gone to the floor. She had called 911. She had called the firm. She had given the paramedics the information they needed. She had watched the ambulance leave. She had stood in the hallway of the Fulton County Superior Court with James Osai's briefcase in one hand and his legal pad in the other, and the case file under her arm, and she had thought, "What do I do next?" She had gone inside. She had told the clerk that the attorney of record had been taken by ambulance, and that she was the supervising attorney's intern, and that she was requesting a continuance. The clerk had told her the motion was on for argument, and the judge would rule on any continuance request from the bench. She had sat at the plaintiff's table. Judge Harlow had come out. He had asked the question. She had said yes, and that was the thing Harold Voss never saw coming. Adiz Amara Mensah had been born in Accra, Ghana in 2000, the second of 3 children, to a father named Kwame, who was a civil engineer, and a mother named Abina, who was a secondary school debate coach and who believed, with the absolute conviction of a woman whose life's work was the cultivation of argument, that the ability to think clearly under pressure was not a talent but a discipline, and that discipline was built one repetition at a time. Abina had coached the National Secondary School debate team for 11 years. She had coached 3 teams to national championships. She had developed, over those 11 years, a specific pedagogy, not about the mechanics of argument but about its architecture. She taught her students that an argument had load-bearing walls, and that the load-bearing walls were not the ones that sounded most impressive, but the ones that held the structure upright when the opposition found the weakest point and pushed. She had taught this at the kitchen table first, to her own children. Before they were old enough to debate formally, before they were old enough for school teams, she had taught them at dinner over rice and stew through questions. What is the claim? What is the evidence for the claim? What would someone who disagreed say? What is the answer to what they would say? What is the answer to what they would say? She had done this every evening. Not as a test, as a conversation, as the shape of how the family thought together. Adiz had been doing it since she was 5 years old. By 12, she was her mother's sharpest student. Not because she was the loudest or the most confident. Those qualities had always belonged to her older brother. She was sharp because she was thorough, because she followed the argument to its conclusion, and then one step further, because she had inherited from her father the engineer's instinct that the thing that failed was always the thing you had assumed was solid. She had been admitted to the national debate team at 14. She had argued at the international level at 16. She had been recruited to 3 universities in the United States on academic scholarships, had chosen the one with the strongest pre-law program, and had graduated in 3 years with the specific, unhurried efficiency of someone who had been working toward a thing for a long time and was not going to waste time arriving at it. She was in her 3rd year of law school. She had a 4.1 GPA. She had published a student note in the Law Review on whistleblower protection doctrine that her evidence law professor had described in the acknowledgments of his most recent article as the most incisive analysis of the McDonnell-Douglas framework's application to retaliation claims I have read from a student author in 15 years of teaching. She had been at James Osai's firm for 2 months. She had been assigned to the Wallace case because the whistleblower doctrine was the subject of her law review note, and because James had read the note and wanted someone who had thought carefully about the framework. She had thought carefully about the framework. She had spent 6 weeks building the opposition's argument on a foundation she understood at the level of its load-bearing walls. She had not planned to argue it. She was going to argue it anyway. And that was the thing Judge Raymond Harlow never saw coming. What was at stake was Cedric Wallace. Not abstractly, specifically. Cedric Wallace was 47 years old and had been a structural engineer for 22 years and had filed a whistleblower complaint because he had found documentation that safety inspections on 3 active construction projects had been falsified, which meant that buildings people were going to live and work in had structural elements that had not been verified as safe. He had filed the complaint. He had been fired 12 days later. His unemployment had run out. He had 2 children in high school. His wife was working double shifts at the hospital. He had been told by 3 other attorneys that his case was strong, but that the discovery process would take 2 years, and that litigation funding was difficult in wrongful termination cases, and that he might want to consider a settlement. He had not wanted to consider a settlement. He had wanted the court to see what had happened and to say, in the language the law used for these things, that what had happened was wrong. James Osa had believed in the case. He had taken it on a contingency arrangement. He had argued the opposition for 6 weeks. He was in an ambulance. Cedric Wallace was in the 3rd row of the courtroom, having come downtown on a Wednesday morning to watch his attorney argue the motion he had been waiting 6 weeks for. And he was watching the intern stand at the plaintiff's table, and his face was doing the thing that a person's face does when they are trying not to show that they are afraid. Adiz had seen him when she came in. She had looked at him for 1 second. That was all she needed. 3 weeks. Harold Voss opened for the defense. He was 58 years old and had argued motions in this courtroom 14 times. He knew Judge Harlow's preferences, the pace he liked, the kinds of arguments he found persuasive, the specific signals, almost invisible, that the bench gave when it was moving toward a decision. He had prepared for this motion as thoroughly as he prepared for everything, which was very. He argued for 12 minutes. He was precise. He was organized. He covered the legal standard for a motion to dismiss under the whistleblower retaliation framework, that the plaintiff had to establish a genuine dispute of material fact sufficient to survive dismissal, that the evidence of causation had to be more than temporal proximity alone, and that the documented performance review process that had preceded the termination provided an independent, legitimate reason for the employment decision that broke the causal chain. He was good. He had been doing this for 31 years, and the 31 years showed in the way they always showed in genuinely skilled advocates, not through effort but through ease. The specific ease of someone for whom the work had become natural. He sat down. Judge Harlow looked at the plaintiff's table. He said, "Ms. Mensah." Adiz stood. She took 1 breath. She had spent 6 weeks on this case. She had read every document. She had built the argument in the way her mother had taught her, from the load-bearing walls outward. She knew what held the structure upright, and she knew where the opposition would push, and she knew what the answer was to each push, and she knew what the answer was to the answer. She began. She did not begin with the legal standard. That was the conventional opening, and it was correct, but it was not the first thing. The first thing was the fact that Harold Voss had just argued that the performance review process was independent of the whistleblower complaint. And the first thing she needed the court to understand was that this independence was not established by the documents, but by a characterization of the documents that the documents themselves did not support. She said, "Your Honor, the defendant has argued that the performance review process that preceded Mr. Wallace's termination was independent of his whistleblower complaint. I want to direct the court's attention to a specific document that the defendant has described as the initiation of that process." She had the document tabbed. She had tabbed every document she intended to use, in the order she intended to use them, the night before, not last night, 3 weeks ago, when she had built the argument in her notebook at the kitchen table in her apartment, in the way her mother had taught her, from the load-bearing walls outward. She said, Exhibit C, page 4, the email from the project manager to HR, dated September 7th, which the defendant has characterized as initiating the performance review process. She paused. She said, "Your Honor, September 7th was 6 days after Mr. Wallace's internal complaint was filed. Not 6 months, 6 days." Judge Harlow looked at the exhibit. Harold Voss did not move. He was very still. Adiz continued. She said, "The defendant has represented to this court that the performance review process began 6 months before the complaint. That representation is based on a memo from the project manager dated March 14th that lists performance concerns. I want to direct the court's attention to the metadata attached to that memo as Exhibit F." She had the exhibit tabbed. She said, "The metadata shows that Exhibit F, the March 14th memo, was created on September 9th, not March 14th, September 9th, 2 days after the email initiating the performance review. 8 days after the whistleblower complaint." The room was quiet. Judge Harlow looked at Exhibit F. "If you need to know what happened next, subscribe." Because what Judge Harlow said when he finished looking at the metadata is not something Harold Voss had prepared for, and it is not something the courtroom clerk will forget easily. And it is the moment that Cedric Wallace, in the third row, let out the breath he had been holding for 8 months. Harlow looked up from the exhibit. He looked at Harold Voss. He said, "Counsel, you characterized the March 14th memo as initiating the review process 6 months before the complaint." Voss said, "Your Honor, we relied on," Harlow said. "The metadata shows it was created September 9th." Voss said, "There may be a technical explanation for," Harlow said. "There may be." "Do you have it with you?" A pause. Voss said, "I would need to confer with my client." Harlow said, "You have relied on this document to establish the independence of the review process. The plaintiff has introduced evidence that the document was created after the complaint. This is a factual dispute of considerable materiality." He looked at Adiz. She said, "Your Honor, if I may, the standard for surviving a motion to dismiss is whether the plaintiff has raised a genuine dispute of material fact sufficient to go to trial. The metadata evidence creates exactly that dispute. The defendant's characterization of the review process as independent of the complaint is contradicted by the creation date of the document on which that characterization rests. That is a genuine dispute of material fact. The motion to dismiss should be denied." She sat down. She had been standing for 19 minutes. Judge Harlow looked at his notes. He looked at Exhibit C. He looked at Exhibit F and its metadata. He looked at Harold Voss, who was conferring in a very low voice with his associate. He said, "Mr. Voss, does the defense wish to respond to the metadata evidence?" Voss stood. He said, "Your Honor, the defense was not aware of the metadata discrepancy prior to this argument. We would request an opportunity to investigate the technical basis for," Harlow said. "You would request a continuance?" Voss said, "Yes, Your Honor." Harlow looked at Adiz. She said, "The plaintiff opposes a continuance, Your Honor. The defendant has had 6 weeks to prepare this motion. The document and its metadata have been in the plaintiff's production since week 2 of discovery. If the defense was not aware of the metadata, the issue is one of preparation, not of new evidence." Harlow looked at Voss. Voss said, "Your Honor," Harlow said, "the motion to deny a continuance is well taken. The evidence was available." He looked at the bench. He made a note. "The defendant's motion to dismiss is denied. The case will proceed to discovery on the merits." He looked at Voss. "I would note for the record that the court takes seriously the implications of the metadata evidence for the integrity of the documents produced by the defendant in this matter. The plaintiff may wish to consider the appropriate motions." He looked at Adiz. He said, "Ms. Mensah," she said. "Your Honor," he said, "how long have you been practicing?" She said, "I'm a third-year law student, Your Honor." "This is my first argument." The courtroom clerk looked up from her notes. Harlow looked at Adiz for a long moment. He said, "Tell your supervising attorney I hope he recovers quickly," he said, And tell him his intern knows how to build an argument. He stood. Everyone stood. He left the bench. Adiz sat at the plaintiff's table for a moment after the courtroom cleared. Her hands were not shaking. She noted this with the specific, observational precision of someone who has been taught to assess themselves accurately and finds accuracy useful. Her hands were not shaking. Her heart rate was elevated. Her legs were slightly unsteady, which she discovered when she stood. She stood. She picked up James Osai's briefcase and his legal pad and the case file. She walked into the hallway. Cedric Wallace was there. He was standing by the window. He had his back to her. She could see, from the set of his shoulders, that something in him had changed in the 44 minutes since she had looked at him in the third row and seen his face doing the thing it did when a person was trying not to be afraid. He heard her come out. He turned. He looked at her. He said, "I don't know what just happened in there," she said. "The motion to dismiss was denied." "The case goes to discovery," he said. "What does that mean?" she said. "It means the judge found that you've raised enough factual questions that the case deserves to be heard." "It's not a win, it's the right to have the fight." He said, "That's enough," she said. "It's a start." He looked at her. He said, "How old are you?" she said. 23. He said, 23. He said, "You argued my case in front of a federal judge and you're 23 years old," she said. "Superior Court." "Not federal," he said. "Is there a difference?" she said. "Yes, but it doesn't matter right now." He looked at her. He said, "I filed that complaint because people were going to be in those buildings. People who don't know the inspections were faked. I lost my job. My wife has been working double shifts." He stopped. "I needed someone to tell me it was worth it," she said. "It was worth it." He said, "How do you know?" she said. "Because you're still standing here." He was quiet. She said, "Mr. Wallace, the case is going to be long. Discovery is 6 months minimum. Trial could be another year after that. James Osai is going to recover. I spoke to the firm 20 minutes ago and he's stable, and he's going to be your attorney of record when he does. But today was real. What happened in that room today was real," he said. "What happened today?" she said. "A judge looked at the evidence and said there's enough here to be heard. That's not nothing. That's the system working the way it's supposed to work." She paused. "It doesn't always work the way it's supposed to work. Today it did." He looked at the floor, then at the window, then at her. He said, "Thank you," she said. "I did my job." She walked to the elevator. She called her mother from the parking garage. Abina Mensa picked up on the second ring. It was evening in Accra. She had been waiting. Adiz had texted her that morning when James Osai collapsed, and Abina had been waiting with the specific, disciplined patience of a woman who did not call first, because she knew her daughter would call when there was something to say. Adiz said, "The motion was denied." Abina said, "Tell me." Adiz told her, not the outcome first, the argument, the load-bearing walls, the metadata, the sequence, the way each piece had connected to the next. Abina listened without interrupting. When Adiz finished, Abina was quiet for a moment. She said, "What did the judge say when you told him it was your first argument?" Adiz said, "He said to tell my supervising attorney that his intern knows how to build an argument." Abina was quiet. Then she said, "Do you remember the kitchen table?" Adiz said, "Yes," she said. "What is the claim?" Adiz said, "The termination was retaliatory." Her mother said, "What is the evidence?" Adiz said, "The timing, the metadata, the backdated document." Her mother said, "What would someone who disagreed say?" Adiz said, "The performance review was independent." Her mother said, "What is the answer to what they would say?" Adiz said, "The document that establishes the independence was created after the complaint. The metadata proves it." Her mother said, "What is the answer to what they would say?" Adiz said, "They needed a continuance to find one. They didn't have it." Her mother was quiet for a moment. She said, "The kitchen table was always the courtroom." Adiz stood in the parking garage of the Fulton County Superior Court with her mother's voice in her ear and James Osai's briefcase in her hand, and the specific, particular exhaustion that follows 44 minutes of building an argument at full concentration. She said, "I know, Mama." Her mother said, "Are you all right?" She said, "I'm good." Her mother said, "Come home in the summer." She said, "I will." Her mother said, "Your father wants to know if the metadata argument was in the brief or if you developed it in the room." She said, "It was in the brief. James flagged it 3 weeks ago. I organized the presentation." A pause. Her mother said, "He says good engineering." She said, "Tell him thank you." She got in her car. She sat for a moment with her hands on the wheel. She thought about the judge's question, "You think you can win this?" She had said yes without thinking about it. Not because she was certain, she had not known what was going to happen in the room, but because the question had a load-bearing wall in it, which was, had she done the work? She had done the work. If you had done the work, the answer to the question was always yes. She started the car. She drove back to the office. James Osai was released from Grady Memorial 3 days later, stable. A cardiac arrhythmia, caught early, treated, manageable. He would be back at the office in 2 weeks. His associate called Adiz the day he was released. He said, "James wants to talk to you when he's home." She said, "Is he all right?" He said, "He's fine. He watched the hearing." She said, "He watched it." He said, "The clerk recorded it." Standard procedure. James's wife pulled it up on the hospital TV. A pause. He watched the whole thing from his hospital bed. She was quiet. He said to tell you that you used the metadata exactly the way he would have used it." She said, "I used it the way it needed to be used." He said, "That's what he said too." She said, "How is he really?" He said, "He's good. He's annoyed that he missed it." He's at a pause. "He's proud. He told me to tell you that. He's proud." She sat at her desk in the intern office, a small room at the end of the hall, shared with 2 other interns who were both out that afternoon, and she looked at the Wallace file on her desk and the tabbed exhibits and the legal pad with the argument structure she had written 3 weeks ago from the load-bearing walls outward. She said, "Tell him I'll see him when he's back." She hung up. She opened the Wallace file. Discovery started next week. She had work to do. 6 months later, the Hargrove Building Solutions case produced one of the more significant discovery findings in a whistleblower retaliation case in Fulton County that year. The metadata evidence that Adiz had surfaced in the motion to dismiss argument led to a broader examination of the firm's document production. That examination found systematic alteration of timestamps across 14 documents. The finding was referred to the state bar for potential sanctions against the defense counsel, and to the Department of Labor for a separate investigation into the safety inspection falsifications that had been the subject of Cedric Wallace's original complaint. The case settled 11 months after the motion to dismiss was denied. The terms were confidential. What was not confidential was the fact of the settlement and the fact that Cedric Wallace had received it, which was the fact that mattered to the people who asked about it. James Osai returned to the office 6 weeks after his hospital stay. He was different, not diminished, just recalibrated. The specific recalibration of a person who has been in a situation that required them to examine what they valued. He worked slightly shorter hours. He delegated slightly more. He paid slightly more attention to the interns. He gave Adiz the first author credit on the case note they co-wrote about the metadata argument and its implications for document production in whistleblower cases. The note was published in the Georgia Bar Journal the following spring. She was in her first year of practice at a civil rights litigation firm in Atlanta when it was published. Her name was on the byline. She sent a copy to her mother in Accra. Abina Mensah received it on a Tuesday. She read it at the kitchen table, the same table. She read it twice. She set it down. She picked up her phone. She called her husband. She said, "Quame." "The article is here," he said, and she said, "She built it from the load-bearing walls outward." He said, "Of course she did," she said, "Of course she did." She put the phone down. She sat at the kitchen table, where she had asked the same questions every evening for 20 years. What is the claim? What is the evidence? What would someone who disagreed say? What is the answer? What is the answer to the answer? She sat there for a while, then she got up. She made tea. She went to the window. The city was outside. The world was going about its business. Somewhere in it, her daughter was building arguments from their load-bearing walls. That was enough. That was everything. There is a kind of preparation that does not announce itself. It does not arrive as confidence, it arrives as readiness. The difference is that confidence is a feeling and readiness is a condition. You can feel confident without being ready. You can be ready without feeling confident. What happened in the Fulton County Superior Court on a Wednesday morning in March was not confidence. It was a 23-year-old woman who had been building arguments from their load-bearing walls since she was 5 years old, standing in a room where an argument needed to be built. And building it. She had not planned to be there. The room had not planned for her. Judge Harlow had not planned to ask his question or to receive the answer he received, but the preparation was already there. It had been there for 18 years. The room simply gave it somewhere to go. Here is the question this story leaves behind. What have you been building, quietly, at kitchen tables, in notebooks, in the evenings after the day's work is done, that has not yet found its room? And are you still building it, even when the room hasn't appeared yet? Because the room appears. It appears when a supervising attorney collapses in a hallway. It appears when a judge asks a question he doesn't expect to have answered. It appears when someone looks at you and says you think you can win this, and the only honest answer for a person who has done the work is yes. Keep building. If this story stayed with you, share it. Subscribe. Stay close. The next one is coming, and it starts the same way, with a room that wasn't expecting the person who walked into it. And ending the same way, with the person the room wasn't expecting being exactly who the room needed. Drop a comment. Tell me who taught you that an argument was something you built, not something you made. Let them be seen, even here, even now, because everybody deserves to be seen.